for coffee, and after that we will reassemble for the first session, the judicial perspective of law reform. A convention, sir. Now we will go ahead with the first session of the symposium, judicial perspective at law reform. I would request the honorable dignitaries to take their seats on the dais. Chairman Justice Shri N. Venkatachala will be chairing the event. I would also like to invite the other of our guests to be on the dais. Justice A.J. Sadashiva, Justice R.J. Babu, Speaker of the session, Justice Vasant Kumar, Moderator of the session, I am also requesting Mr. K. Jaiprakash Hegde to join us on the dais, and Mr. V.R. Sudarshan would also be joining us on the dais. Sir, Justice Venkatesh Murthy. Sir, kindly please join us on the dais. First session of the symposium, First Thoughts at Law Reform. Honorable Justice Shri N. Venkatachala is with us throughout the session and he will be chairing this event. I would request His Lordship to kindly accept the chair and lead us through the event. We have Justice R.J. Babu with us, the speaker of the event. Justice Babu, he took to practice after a brilliant academic career in the year 1968 and was president of the Karnataka State Commission of Jurists during 1989-90, appointed to the Karnataka High Court in the year 1994 and was then transferred as a judge of the Madras High Court in 1994, and after His Lordship resigned, after His Lordship retired from active judicial service, His Lordship has been engaging continuously in intellectual and social thought at reform. I would welcome Justice R.J. Babu to be here and lead the initiate the debate. And we have with us Justice R.V. Vasant Kumar. He would be the moderator in the event. Justice R.V. Vasant Kumar, educated at the Central College and the Government Law College, Bangalore, took to practice of law in the year 1955, joined the chambers of Shri V. Krishnamurthy, appointed Judge of the High Court of Karnataka in 1991, and after retirement was Vice Chairman and subsequently Chairman of the Karnataka Administrative Tribunal. I, on behalf of KILPAR, would welcome Honorable Justice R.V. Vasant Kumar to moderate the event. Justice S.R. Venkateshamurthy, a Josephite, studied in Sharda Vilas Law College, Mysore, secured his master's degree in law, and joined judicial service as Munsif and was promoted as district judge in 1985, was the first registrar of the newly constituted city civil court and also the first registrar of the Karnataka Administrative Tribunal. His Lordship worked as the additional registrar of the High Court of Karnataka before he was appointed as additional judge of the High Court of Karnataka in 1997 and was later elevated as the permanent judge in 1998. His Lordship has served as the governor of the Karnataka Judicial Academy and was vice chairman of the Karnataka Administrative Tribunal. His Lordship has been with us. I welcome His Lordship to be with us as the guest participant at the event. So I would request Justice R.J. Babu to initiate the dialogue. Thank you.
Honorable Mr. Justice Venkatachala, my brothers Justice Sadashiva, Justice Vasant Kumar, Justice Venkatesh Murthy, Sri Dakshina Murthy, and all the participants in the seminar present here. At the outset, I must really congratulate the government of Karnataka for a very good initiative they have taken in constituting this forum. Although a great deal is said about the law being a profession which is learned, not much effort indeed has been made by those in authority to encourage that learning in a way that will be productive. What has been lacking in our system is the critical faculty. There is hardly any critical study of what is being done, hardly any assessment of institutions that are working, and a re-evaluation of the existing setup with a view to find out where the defects lie and how they can be addressed and made better for the future. So this kind of an institution was really very necessary, and I hope it fulfills the aspirations with which it has been founded. It really should function as a think tank for the government to give them ideas as to where remedial action can be taken, how soon it can be done, how effectively it can be done, and to also suggest new areas where new legislation can be formulated and how well can it be brought into existence. I was asked to speak about the judicial perspective on law reform. I have understood this to mean that it is the way in which the reform in law would be desired by those who belong to the judiciary. I read from the published handout that this law reform is here understood in a much wider perspective, as including even the functioning of the judicial institutions and the government. But I will only briefly touch upon that and say a little about the law reform that a person in the judiciary would regard as being necessary. First and foremost, what strikes any judge when he is required to examine a law is the want of clarity. Laws often do not clearly set out what exactly it commands or intends to command. And that's where all the trouble begins, because the citizen does not know where he stands in relation to the law. He has to seek advice, and lawyers can give as many opinions as there are lawyers. There are bound to be differences in approach, and ultimately it lands up as litigation in courts, starts in one level and goes on to the highest. And in the meantime, the person who suffers most is a man who has started the litigation because he does not know the end result and what shape it will take. In his foreword to the Income Tax Act written by Balkiwala, he mentions an instance where litigation which commenced at the lowest level, passed up to the highest, suffered reversals at every stage. What the trial court was upset by the appellate court, what the appellate court said was upset by the court above, and what the court above said was finally upset by the final court. So the uncertainty docks the person who enters the portals of law because he does not know where he will end up. And a great deal of this can be avoided if only the law is clearly written and it conveys exactly what the legislature intended to convey. Here again, the way in which the law is looked at by the legislature or the parliament and by the courts, they do not always tally. They don't see eye to eye on this, not only here but all over the world. There was a study in England written by an English professor which catalogued the cases where Parliament had to enact legislation over again because the court, in the view of the Parliament, had misunderstood the law. What the court declared as the parliamentary intent was subsequently declared by Parliament not to have been its intent but something different. So this kind of a phenomena occurs again and again. It has happened in India also in many cases. And especially in the field of income tax, you have numerous laws which all say this is clarificatory. It is called clarificatory because in the view of the Parliament, the courts which had interpreted the provision had wrongly understood the provision, and therefore they want to set it right. So the court say this is what we clarify as having been our true intent. This kind of exercise again would be unnecessary if you were clear in the first place. If you said exactly what you wanted to say in words which clearly conveyed the thought and said it effectively. And the second area, again relating to draftsmanship, is inconsistencies. The same enactment says one thing in one place and a slightly different thing in another place. So this creates conflict, which again calls for interpretation. Then again, ambiguous usage of terminology, terms which are capable of being viewed at, understood in different ways by persons who have interest in having it declared as conveying a different thought. Now this again is something which is preventable, avoidable, and should be avoided to everyone's benefit. So where is the remedy for this? The remedy lies in the government. It is not in the hands of the court. The court cannot draft the law. The judges cannot say, look, I have found your law to be defective, here is my draft, take it and implement this as the new law. It can only put the ball back to the legislature. And if the legislature commits the same time a mistake, the whole thing goes on over again. So the remedial action should be initiated within the government. And where is this remedial action to be taken? Parliament and legislature, they do not draft the bills. The bill is drafted by the executive. Ultimately, it is the executive which must improve itself, which must address itself to acquiring the skills required for drafting legislation which is apt, current, which can convey what it seeks to convey and says it in clear enough language without ambiguity. And here, unfortunately, the Indian mindset is still a colonial mindset. We still haven't discovered our freedom to think freely and to think for ourselves. Every time legislation is required, the first thing the draftsman does is to look for legislation, if it's a new area, to look at an English enactment. And then copy it as much as possible. If he can make some changes, he will do so. Otherwise, he will be happy to borrow from what another state in India may have done. But beyond that, there is no attempt at creating something on one soul which would suit the milieu in which the Indian society functions. The other extreme is to simply allow laws to lie without any modification whatsoever. We have enactments in our statute books which are 100 years old, some even longer. Enactments which badly need to be reassessed, to be re-evaluated, to find out whether they suit today's changed conditions, whether they answer today's requirements. That exercise remains not even attempted. This is again an area which breeds litigation, and ultimately the courts have to resolve it and say what the law or how the law should be looked at having regard to today's circumstances. There are occasions when the court gives advice which in the view of the government apparently is unsolicited. They do not seem to care much for the advice which the courts sometimes tender while dealing with legislation. When they find some error, they would also say, these are the corrective steps that are desirable. And all too often, those corrective steps are never taken. It remains only a part of the judgment which is not implemented. There is no attempt to benefit from a critical evaluation of the law which the court has carried out so that the quality of the legislation can improve, so that gaps which the court has found are properly filled. And gaps, there are many. One of the examples of this is the case where women at workplace did not have adequate protection so that their status as women remained unharmed. The Supreme Court had to intervene. In the case of Vishaka, the court practically wrote down legislation. It catalogued various things which are to be provided for. It nominated persons who should ensure and implement those laws. This was, of course, an instance of judicial lawmaking. But then the court found that it was necessary because Parliament had not addressed itself to this issue and had not taken any steps to meet a need which was waiting to be met. Therefore, a protective cover had to be extended. But even after this, surely the Parliament and the legislature should wake up and say, look, we have omitted to do something which the court has now done, so let us address the issue now and enact a law which will take care of the circumstances. Even that has not been done. And who is to blame for this? Ultimately, again, it is the executive government which must take the initiative in drafting the legislation, bringing it before the legislatures and the Parliament, and ultimately see that the needs of the society are well met. Now again, the courts are there to uphold the Constitution, to ensure that the legislatures remain within the fields allotted to them under the Constitution, that the legislatures exercise their powers on subjects which are within their scope and sphere, and that in case of any conflict, to decide which law is to prevail over the other. Now, legislation should be the result of careful thought, careful drafting, careful debate about the wisdom or otherwise, and as to whether it is necessary, whether it is in conformity with other laws. The initiative is taken by the executive, but the ultimate decision is that of the legislature and the Parliament. Unless they debate the issue in an informed way, what will emerge is merely the draft which somebody in the law department has put up. Ultimately, it becomes the law, because legislature did not find time to debate, or legislature did not have enough interest in looking at the matter in sufficient detail. So what you have is a law which emerges, which is supposedly made by the Parliament and the legislature, but is in effect, in reality, the draft prepared by some officer somewhere down the line, whose vision surely is not in any way equal to the collective wisdom of the legislators and the parliamentarians. The power to enact a law, which is such a precious power, is vested in these bodies of elected representatives, so that they bring to that task all their wisdom and all their knowledge of society and its affairs. And that fails if it does not find enough time to look at the law which it is being asked to consider and ultimately enact. Now, there are also occasions when courts have to grapple with what the executive government does in terms of ordinances. In order to avoid legislative debate perhaps, or in order to somehow enact a law without loss of any time because of whatever agenda the party or the executive may have, ordinances are issued. And many a times these ordinances lapse because ultimately they do not have the confidence that it will pass muster in the legislature or the Parliament. It is a short-term gain which they want for the time being, which succeeds. And this is an abuse of power. This is not the purpose for which the power was vested under the Constitution. Now, such things certainly result in the courts coming down heavily on persons who indulge in this, and this kind of a thing ought not to be done. So